actionable and does not violate any rule of professional conduct for lawyers. As a matter of fact, neither Dr. Ayeni nor we in MDC can be compelled, and I repeat, can be compelled to increase our confidence in the independence of the judiciary, even when the court has not given us any basis or reason so to do. The Chief Justice ought to be reminded that according to Article 125 of our Constitution, justice emanates from the people and is administered on behalf of the Republic by the judiciary, who shall be independent. Public confidence in the independence of the judiciary must therefore be earned and not be forced on us. Nobody can force anybody to have confidence in a system that does not justify that confidence. It is naturally not possible. So if you want me to have confidence in you, you must demonstrate by your actions that you deserve that confidence. I cannot be compelled by any dictator to have confidence in anything that I don't have confidence in.
That was the General Secretary of the National Democratic Congress, the biggest opposition party in the country. If you're watching us on Facebook, tell a friend to tell a friend to tell another friend that we are airborne, and that you can share the Facebook Live for other people to also watch tonight's edition of the program. Today we are looking at this issue from the legal perspective, whether or not the National Democratic Congress has an issue. They have raised a lot of issues and all of that. In that press conference, they've also accused the judiciary. They have accused the Supreme Court of, acting in bad faith with regards to the election petition, and I'm talking about the 2020 election petition. They attacked also the credibility of the Chief Justice. But I've been joined in the studio by lawyer Al-Hassan Fatal, popularly known as Joe Faisi, private legal practitioner. He's going to help us understand some of these issues, properly. Lawyer, good evening. Good evening. You deserve an honorable. I nearly called you honorable. Very soon. You are the honorable to
Thank you so much. Good evening to your cherished viewers. Thanks for having me once again.
Very well. It's been a while on this platform.
Yes, it has.
Now let's look at the National Democratic Congress's press conference. I mean, people are reviewed that the statement made by Dr. Dominic Ayeni, former, Deputy Attorney General of this country, was to scandalize the court, and the court shouldn't take it lightly. In order for the Chief Justice to protect the integrity of the court, that's how come he dragged them to the General Legal Counsel for, disciplinary actions to be taken. Why then would a whole party, the former Deputy Attorney General belongs to, hold a press conference on this to express their dissatisfaction and also back the Deputy Attorney General, former, on the statement he made? Is it right?
Thanks so much, Justice. Well, I would say that when Dr. Dominic Ayeni made the first statements, you remember during the pendency of the election petition, he did make some statements, which statements were found by the Supreme Court not to be in good taste.
Okay.
And so he was actually dragged before the court.
Okay.
At that instance, the National Democratic Congress as a party did not hold any press conference on it. Because constituting the minority caucus in Parliament are very seasoned lawyers as well.
Okay.
You understand? So they know when it is proper or right to do what and when it is not. Knowing very well that the case was still pending in court, as lawyers, it amounts to a professional misconduct to comment on the proceedings in a way that would be prejudicial to the outcome of the proceedings in court. And so when Dr. Dominic Ayini made those comments at that material moment, when the matter was still pending in court, you realize that the NDC did not come out to make to hold any press conference on it. And Dr. Dominic Ayini himself did not mince words in retracting those comments and going ahead to make an apology. You understand? And so you would see that the NDC knows what it is about. The first conduct was quite reprehensible. And the party did not come in at that moment. The maker of that statement at that particular moment also withdrew the statement and apologized.
In other words, are you saying that the current, statement he made are not those that are reprehensible?
At all.
Why do you think so?
Yeah, I say that because one, it is a post ex facto statement that he made, a statement made after the event. You know, even though lawyers are not supposed to make comments on proceedings that are cases that are pending in court after the matter has been determined. In fact, we are even encouraged to critique those judgments and pass comments. You understand? Because it is by critiquing these judgments that you get the quality justice that we all desire. We are all talking about a just society. We are all talking about a free and fair society. We are all talking about a democratic society. These things are ideals that have to be worked for. You don't expect them to come hook, line, and sinker. You have to work for them. And by allowing some of these expressions to flow, that's when you get a richer discourse around the subject. And remember, Dr. Dominic Ayini made this statement not in pursuit of his professional conduct. He was not talking as a lawyer. You understand? He was merely talking, one, as an academic, and two, as somebody who may have also participated in these proceedings. And so, when you are charging somebody for professional misconduct, which obviously is where this is leading us to, the person should have conducted himself or misconducted himself at the time he was involved in his professional duty. That means that at the time he was performing his duty as a lawyer.
In which capacity was he invited to the CDD program?
Yes, the CDD program, he was invited, one, as an academic. Two, as the chairman of the subsidiary legislative committee of parliament. Nowhere was it stated in his invite that he was being invited because he's a lawyer. No. Maybe perhaps we could also say because of the insight he may have gained from participating in these proceedings. You understand? But obviously he was not there performing the role of a lawyer. You understand? Because there were equal other participants there. So he was not there to perform the role of a lawyer, and so he was not engaged in his professional conduct, for which reason anybody can cite him for misconduct. You understand? But looking at the earlier one that happened, there was a proceeding in court on the day. Right after the proceeding, it was part of the arrangement that lawyers would speak to the media after the proceedings. So after that day's proceedings, he came out of the court, addressed the media, and that was where he used those words. So he made those remarks. So we could say that at that material moment, he was engaged in a legal professional conduct. You understand? As a lawyer. So for those remarks can be taken up.
Remarks you have made before, that you have apologized. What then would come over you to make those remarks once again?
No, you see, the timing is important. When the matter is still in court, you are not allowed to make those comments on them. But you are allowed to criticize judgments after they have been delivered. In fact, in certain states, in fact, in the US, attempts were made to compel lawyers to criticize judgments and to even put in those rules that if you fail to criticize a judgment that were palpable clear to you that they wanted criticism, you were even guilty for misconduct. attempts were made, but they never saw the light of day because you know sometimes when they open the floodgate for people to criticize judges and their judgments, sometimes you are so much engulfed in criticizing a judge, sometimes you find it difficult to even appear before that judge because you may not even be able to get justice. You understand?
I'm not sure the Supreme Court is preventing anybody from criticizing its judgments and all of that.
Okay.
But we must do that constructively. Is that true or false?
That is it. In fact,
did he criticize the Supreme Court and the Chief Justice constructively?
That is where the line is. Because who now tells what is constructive, what is not constructive?
Okay.
Who draws the line between what is an insult and what is criticism? That is where we are at the moment. You understand? But Dr. Dominic Ayini is not new to the legal fraternity.
Okay.
You understand? He knows what is acceptable and what is not acceptable. We know sometimes you can be driven by emotions. But in this particular instance, Dr. Ayini, you see, and if you look at the forum, the platform that was given him, organized by CDD, and they were to talk about election petitions and their impact on democracy in Africa or on the continent. You needed to spill the beans. You needed to make matters bare. You needed to open them up and let the truth come, because that is an academic platform. And these things, once you begin to sweep them under the carpet, then you are not engaged in an academic discourse. You understand? So it was actually incumbent on him to open matters up, because it is by opening issues up that you can get solutions for them.
Now, you see, let's analyze the statement made on that platform, on that roundtable discussion held by CDD. He sought to question the independence of the judiciary and went further to say that he has lost hope in the judiciary. Are these statements palatable?
Yes.
Could this be, classified as criticisms?
That is an opinion. Whenever an event happens, everybody has the right to see things the way he or she wants. And you can express the way you see things. To the extent that he didn't say that consistently this has been the conduct of the justices of the Supreme Court, but he was specific to an event, the issue of the presidential election petition 2020.
Okay.
He was specific. And so he was making an opinion to me based on an event. And it is not wrong for an individual to make an opinion based on a particular event. It would have been different if he had said that the justices of the Supreme Court have over the years been like this, and so there is no more confidence or there's no independence of the judiciary. But he was specific to an event, the 2020 election, and it was something everybody observed.
Isn't that an attack on the judiciary, especially the Supreme Court?
Let me tell you the problem we have in the country.
What's the problem?
You see, lawyers, nobody can understand the work of judges more than lawyers.
Okay.
It is the lawyer who can tell whether a judge is abusing his powers or is not. A layman may not be able to understand this. Because what does it mean to a layman when they say an application for interrogatories has been thrown out? He won't even understand what it means.
Okay.
Dr. Ayini was saying that the settled practice and precedence that we have established as a country to guide our civil proceedings in our court were all scattered during this election petition.
Okay.
To the extent that whatever we all came to court knowing to be the practices in our courts were no longer observed. And nobody was given due notice of this. And you see, when you are coming to court, it is not surprising, or it is not for nothing, that anybody going to court would go for seasoned lawyers like Chachu. You understand? And Tonilita and Akotampao and all those names.
Okay.
Because they have seen it all. They know what the rules say. They know what the precedents are. So when such people come to court, and then things begin to go in different directions, application of this is thrown out. Application of it, I don't think it is wrong to question this, because we came to court knowing that this is the established practice. And if I am planning my case, I plan my case looking at all the necessary precedents, that if this happens, this will happen. If this happens, this will happen. And so if I arrange my plan in that order and I come to court, and all the established and settled practices in our courts have been jettisoned in this petition, please, don't I have a cause to worry? More so when I am supposed to be concerned about the quality of justice we get, not just justice, the quality of it. And like I said, once lawyers are those who understand the work of judges, to me, they should be those who should be encouraged to critique the work of judges. A layman will not be able to tell when a judge is wrong or right, because he does not even understand the work of that judge in the first place. But in our case as a country, we have non-lawyers who can talk anyhow to judges. We all were here when Kennedy Agyapong spewed those venoms on judges and called a judge as stupid. Till date, nothing has come out of it. And this is somebody who does not even understand the work of judges. But somebody who does understand this cannot criticize. When you criticize, they say you are involved in a professional misconduct. Doesn't mean my profession will now be an instrument.
You are a lawyer. Let's look at what amounts to a professional misconduct. What amounts to a professional misconduct?
You see, we have our LI 2424. You understand? Which is 2020. It has stipulated actions that can amount to. So when they say don't do this, when they say a matter is pending in court, you don't pass comments that are prejudicial. You don't grant this and that. When this happens, don't do this, don't do this. Once, so the LI will tell us the things you should not do. Once you do it, you understand? Yeah. You are involved in a professional misconduct. And clearly, it should be a conduct or a misconduct that came about as a result of the expression of that professional conduct. Because if I am, for instance, I'm a lawyer. Yeah. You understand? And I go to the football field and I start playing football. And something happens as a lawyer, sometimes even your communication to the public, a lawyer and a lawyer, your client, even to the public, is measured. The way you communicate to somebody can amount to a professional misconduct. So as soon as I go to the football field, am I there performing a professional conduct? No. So if somebody approaches me and somebody does anything to me and I use insults, certain unprintable words on the person, you understand? Somebody can say, you are a lawyer. You are not supposed to be using those words on any member of the public. How come you are using those words? But I can say, no, yes, but I am not engaged in my professional conduct as a lawyer. And so the LI 2424 has spelled out what we need to do. And we have the etiquettes and the professional conduct rules. Once you go contrary to any of these, you understand, then you'll be deemed to be engaged in a professional misconduct. You understand? So, and you see, lawyers or non-lawyers, we are all supposed to be acting in the interest of the public. Okay. Is it not a given? Is it not a given that the matter of the Supreme Court election petition was a serious matter for public interest? It was a huge issue. And if people are engaged in letting us understand things that went on in this very important national matter, should we rather not be encouraging them to talk more so that it will help shape future adjudication on such matters?
Now, we'll come to the basis upon which that statement was made. The basis upon which the statement was made is that of the 2020 election petition. We'll come to that. Viewers, if you are watching us on Facebook, kindly share the Facebook Live for other people to also get an opportunity to watch tonight's edition of the program. If you're on Facebook, just search for Pan-African Television with the African map, like our page, watch tonight's edition on Facebook, and share. Please share and like tonight's edition of the program. I'm calling on all persons who are watching us on Facebook to share. Please share the Facebook Live for other people to also get an opportunity to watch tonight's edition of the program. Now, the National Democratic Congress, in their press conference, to back the statement made by Dr. Dominic Ayine at the CDD roundtable discussion, indicated certain things that went wrong in the 2020 election petition. They feel that, well, as a result, what he said wasn't far from truth, and they have backed it. They have also said that they have lost hope in that of the judiciary and all of that. They talked about the dismissal of the interlocutories. They talked about, you know, the conduct of some of the judges, especially that of the Chief Justice and all of that. Are we not still scandalizing the court?
No, it is in our interest to hold the judiciary above some of these criticisms. We all have a duty to protect the image of the judiciary, and I don't think it is in our interest as a nation, as individuals, to act in any way that scandalizes the courts or the judiciary. And if you look at even the response from Dr. Ayine, he says that his remarks in no way amount to disparaging the image of the judiciary. Now
tell us, what exactly went wrong in the 2020 election petition?
I think we've had this discussion a number of times.
We've done so.
I even sitting here, I think I made reference to that, because I did say that any lawyer coming to court would have drawn his plan.
Okay.
To the MDC family, we came to court even looking at what happened in the 2012-2013 election petition, where almost all the settled practices and precedents in our court were observed to the latter. You understand? But in this instance, anything you want to say, to the extent that the courts, we felt, was supposed to be the last resort to compel an institution like the Electoral Commission to remain accountable to the people in the way it conducted its official elections. We were expecting the courts to do nothing less than at least letting the Electoral Commission know that you cannot hide under the cloth or the cover of rules to run away from your constitutional mandated responsibility of accounting to the people of the mandate you were given. Yet this was allowed.
You are a lawyer.
Yeah.
And you are very familiar with these practices. Is it as part of the practices in court and as part of our laws that one can decide not to mount the witness box?
And that's why I've said that this issue has been well discussed here. We are not talking about just mere parties coming to court. We're talking about an election petition that had the whole nation sitting on tenterhooks. You understand? Everybody was looking at. In fact, what was required of the EC was more than what was required of a mere party to a matter in court. The EC was representing the generality of the populace. We gave the EC a mandate, a constitutional mandate, resourced them to perform a mandate, and we felt that the said mandate was not duly performed, and they were supposed, in fact, and even judges in the 2013 election petition, judges, the Supreme Court judges had cause to complain about the fact that the EC was required to supply certain pinches, which they failed to do, and which petitioners then had to rely on their agents to get. So it means that even our courts in the past have realized that the Electoral Commission will not just be a mere party to a suit.
Okay.
They are supposed to be held accountable as a state institution because they were supposed to hold the balance. And having failed to do that, there's no way they should have been allowed to hide under the cover or behind certain rules or practices and say that as a party I have the right to choose whether to come out and give evidence or to stay back and allow proceeding to go. This was not just a normal Part A, Part B matter. It was about a national issue. And we needed to know the truth and correct our systems. Remember, after the 2012-2013 election petitions, a lot of revisions.
Where did the Supreme Court err by allowing a said rule that allows, a witness not to mount the box?
So the rules that allow for the administration of interrogatories, why were they jettisoned? You understand? The rule that allow for admissions, why were they jettisoned? Why were all the other rules that came from the petitioner side not entertained? You understand? So this was an event. The event happened. We have to dissect it. And to me, platforms like what came to the disposal of Dominic Ayini are even needed more for us to appreciate some of the things that happened and perhaps make proposals that would further enrich our practices. Because after the 2012-2013 election petitions, a lot of amendments and proposals were made which went to certain changes we saw in the 2020 elections, broadening some of the transparency issues we had. You understand? And bring it to rest. So if we had allowed certain things to come out in court, trust me, it would have further enriched our electoral processes and made us better. But today, because of what happened in our courts in the 2020 election petition, I'm not sure there will be any proposal. I'm not sure nothing at all would come out of that would further enhance our electoral processes. And it's not good for us as a nation.
Now, decisions that were taken in court during the election petition were unanimous decisions. They were not decisions that were taken by just one person. Some of the decisions were 9-0, some were 7-0, and I think some other ones. Why the attack on the persona of the Chief Justice?
Well, I don't think there's any attack on the...
I'm talking about the NDC press conference.
Yes, because there was an individual who made a complaint to the General Legal Council. So it wasn't a unanimous complaint made by the 9 justices who sat on the election petition, or was a complaint made by all the 9 justices?
No, not at all.
It was made by one person. So I don't think what NDC did was also an attack on the Chief Justice, to me.
Describing him as a dictator and a tyrant.
I will not associate myself with such comments.
Okay.
But what I do know is that the party was only expressing an opinion on a subject matter which has become a national one. And to me, to the extent that it was just one person who filed the complaint, it was only fair that your comments would kind of be directed at that one person. And so it will not be correct to say that the decision were unanimous. Why? Because, trust me, the press conference had very little to do.
Okay. So let's delve into the press conference properly. In some of the paragraphs, they pulled, a judgment by Justice Eniyeboah, Chief Justice of the country. Then Justice Eniyeboah, he wasn't the Chief Justice, in the 2012-2013 election petition. And they indicated that he demanded that the Electoral Commission then, or the Electoral Commissioner then, provided certain documents to aid the court.
To get to the truth.
Of which his decision in the 2020 election petition varies. It was different from that of what he said in the 2012-2013 election petition. He has now been the only person which has been singled out in terms of decisions that were made in the 2020 election petition. He has been singled out of the 9 justices.
You see, and so it boils down to what I said first, that when a petition is brought or when a complaint is made, the complaint was made by one person.
Okay.
So you would have to look at what has happened in the past. You understand? Regarding the complaint and then maybe the complainant. So the paragraph that has been pulled out is just to say that even in the 2012-2013 election petition, when the EC refused to provide certain pin sheets, some justices of the Supreme Court had reason to complain about that refusal and felt that if they had been compelled to provide those pin sheets, it would have helped the court in getting to the truth of the matter. And what has changed in the 2020 instance? Were we not looking for the truth? Was there no feeling that the inability of EC or the refusal of EC to provide those species affected the quality of proceedings in court? Couldn't the court compel the EC to still produce the pin sheets to help the court get to the truth of the matter? Why was the entire load put on the petitioner? And why were we now being told of the normal, that legal expression that we all use, that he who alleges must
has the
prove?
burden of proof.
You understand? In 2012-2013, that same expression was still in existence. He who alleges must prove. But we had cause to complain that if we had pushed the issue, if we had compelled the issue to produce the pin sheet, it would have enabled the court to ascertain the truth. In 2020, the same thing could have enabled the court to ascertain the truth. But in this instance, we covered up the issue. And we felt that our failure to get the EC to be, or the EC chairperson to be in the dock, and the EC to provide the necessary information that was needed, affected the outcome of the election petition. And it has deprived the nation of an enhanced 2024 election. Because if we had conducted 2016 elections the way we did for election petition, the way we did for the 2020 election petition, we will not have had this improvement that EC now tout itself about. You understand? So clearly, you would see, you quoting a paragraph from the NDC presentation, you'll see that they are not just attacking for no reason. You understand? Some of those things were based on some of the things they have picked up. Also observing the media landscape.
I am finding it very difficult to understand the outburst of the NDC, because after judgment, if an individual, including lawyers, have the right to criticize judgment of the court, why are we trying to say that the Chief Justice do not have the right to also petition the General Legal Counsel if he feels that such criticisms or some of those criticisms are scandalizing the court, if that is his conviction?
If you've talked about an individual, and I have gone to talk about the Chief Justice is not just a mere individual. In fact, the Chief Justice, we are not talking about, it's an institution.
Are these individuals including lawyers?
Yes.
Lawyers
say an individual.
Standing.
The Chief Justice is an institution.
Okay.
You understand? It's an institution. And that institution is held in a very high esteem. And so, my conduct as a litigant, my conduct as a mere lawyer, should not be likened to the conduct of Chief Justice, which is an institution. And so we feel that because we all know we have the freedom of free expression, that right to free expression, guaranteed under our Constitution, Article 21, and because we know that the judiciary is always the last resort when our rights are being trampled upon, it becomes a matter of grave concern. You understand? When we are now faced with a situation like this. And so I do not think that you should refer to the Chief Justice as just any individual like myself sitting here, a mere lawyer, or yourself, a mere journalist. No, it's an institution, and this institution is where you run to when you feel there's an abuse of your rights, and when you feel someone is gagging you from expressing your right to free speech.
Would you say that the Chief Justice, in his decision to drag Dr. Ayini to the General Legal Council, he's been intolerant?
Well, you see, maybe his thinking or his opinion is that, judges make decisions, and upon hindsight, if you give them the opportunity, they would overturn their own decisions. And in law,
you think that in this decision, if the Chief Justice,
I'm just passing my point. And in law,
you know
when we have, for instance, a judgment that is deemed to be void, you can pay the case law. You can take it before the same judge who made that void judgment, and he can set his own judgment aside. You understand? So which means that it is not everything that a judge says today that he will even stand by tomorrow. For all you know, certain things are not pointed out to him. Which is why I believe that even though Dr. Dominic Ayini is being dragged to the General Legal Council, it is my firm belief that if the petition is not withdrawn and he goes ahead to face the General Legal Council and the matters come out, it will be, they may just see it as an exercise in futility. You understand? Because clearly the man was not in the same position he was. And references in the letter that was addressed to the General Legal Council, references were made to his conduct in the election petition, which to me is unfortunate, because that situation is different from today. He was not supposed to do that at the time, but now he's supposed to criticize. He was not even supposed to criticize at the time because the matter was in court. But now he can. In fact, he's supposed to be encouraged to criticize. And so when we have two different scenarios and statements are made pulling the two scenarios to become like one instance where you are told not to do this, you are doing this. Meanwhile, he being aware, he knows that during the pendency of an action, it is unlawful, it is a professional misconduct to be engaged in this. But after, you can pass post facto comments. You understand? To criticize the judgments. And like I said, in the US, those things are part of their proceedings.
Questioning the independence of the judiciary, especially the Supreme Court, is one that is a serious issue, isn't it?
It is. But remember, like I said, he nailed it to a specific event. Which is what most people don't see.
Once you refer to an institution as one that is not independent, it means that there are some manipulating powers behind it, generally.
That's your own extrapolation.
Because you're saying that they are not independent. Then what's his definition of the court not being independent?
You see, he says, he was speaking specific to the 2020 election petition in the Supreme Court. And he was saying that the way events turned out at the Supreme Court gave him cause to worry. And there are some of the reasons why he would believe that for the way the court conducted itself, they were not independent. That is far from saying, in fact, and if you read his response, he says that he has never in any instance stated that there's anybody manipulating anyone or anybody controlling the mind of any person.
But the independence being questioned, where the independence means...
They are saying, he was saying that in the particular instance of the election petition, the way matters went, he feels the justices were not independent. For maybe we need...
So we need clarity on the judges not being independent in the 2020 election petition. I mean, there should be some sort of clarity.
But where is it the first
time? Judges means, you know, Ghanaians would want to understand that persons who...
Which is why I am telling you that maybe by the time this whole GLC matter is concluded, we would see that we're just involved in an exercise that was to take us nowhere. Because, for instance, he's explained in his own distance, in his response, what he means by what he said. And he said that his statements were not meant to disparage anybody. And they actually did not. You understand? He's a lawyer, he knows what he's about. If people like us, some of the junior lawyers, we may maybe sometimes find ourselves in some of this, but he knows what he's about. And I have that confidence that Dr. Dominic Ayini was supposed to give clarity to the discussion. He was supposed to give justice to the discussion, given the platform he had as an academic and as the chairman of the Subsidiary Legislative Committee of Parliament. He was supposed to speak to the matters, because these are things that would inform happenings in even other African countries, because they were represented from other African countries. And so he was just involved in an exercise that was meant to enrich our political and democratic discourse.
I feel that I asked a question and there wasn't any direct answer to that. Do you think that the Chief Justice was being intolerant by dragging the former Deputy Attorney General to the General Legal Counsel? Also, I would want to add this question to that particular one to be answered. Do you think that this, decision is also made in order to gag people from criticizing the court?
Some of us have the feeling that so long as it is not wrong for us to criticize judgments of courts, we would find it difficult to understand why, in the instance of Dr. Dominic Ayini, he is being hauled before the General Legal Counsel for comments that were only meant to criticize the court in the conduct of the 2020 election petition. You understand? To us, his comments were fair comments. They were comments, in fact, when he made the earlier comments, realizing that he had gone off board, quickly he apologized. This one, post ex facto, the matter was settled. And it is right that such instances you can pass comments. And I am yet to get to that level where we will say that this statement is scandalous. This statement is disparaging. Because to me, if you do not define these boundaries very well, in the end, that free speech that we want to promote will rather be curtailing free speech. And we are still young. Once we begin to put this culture of silence in ourselves, then trust me, the growth we anticipate as a young democracy will not be forthcoming. You understand? So, honestly speaking, Dr. Ayini's comments to some of us, his comments were fair. He was doing what any other person would do. And like I stated earlier, no one understands the work of a judge than the lawyer. The public does not understand. But you look at it, when the lawyer who understands the work is trying to criticize the work, because he comes under some special rules, he's told that he's involved in a professional misconduct. But the public, any member of the general public, would make even more scandalous. What is more scandalous than calling a judge a stupid person? This is the height of something you can call a scandal on the judiciary. But these things, it looks like they are not engaging our attention, rather. It is an academic expression of someone's opinion, which has rather taken effort. And trust me, if this matter had not even been referred to the GLC, by now, a lot of people would have forgotten that. Even most people wouldn't have even heard that Dr. Dominica Ayini made some of these statements. So to me, it is even, this approach is even enlarging the picture. You understand? Making things seem bigger than they actually are. To me, even in the quiet, he could have been called and maybe spoken to, because he is one of the key pillars of our judiciary. He's been a deputy attorney general. A deputy attorney general would work closely with the judiciary. And today, he is the chairman of the subsidiary legislative committee. And that committee is key in the work of the judiciary. Because day in, day out, we pass laws, we pass other instruments, and most of them go through such an individual. And so, he'll be the last person to be making comments that will scandalize our courts.
All right, viewers, you're still watching Hot News right here on Pan-African Television with me, Justice Appiah. Keep your messages coming in on our WhatsApp/text line. Keep your messages coming in on our WhatsApp/text line on let me briefly get you the number on 0544 235984, 0544 235984. Once again, our text line is 0544 235984, 0544 235984. Keep your messages coming in on our WhatsApp/text line, the number I have just mentioned, and we'll make a time to read all those out for you. You can as well leave your suggestions, questions on our social media pages, Facebook, Instagram, and on Twitter. We'll make a time and also read all those out for you. We are live on Facebook, and those of you watching us on Facebook, please share the Facebook Live for other people to also get an opportunity to watch tonight's edition of the program. Please, if you're watching us on Facebook, please share the Facebook Live, like tonight's edition of the program, share, but please make sure you share as many times as you can for other people to also have an opportunity to watch tonight's edition of the program. Now, if you look at the statements made by the NDC as a party and that of the former Deputy Attorney General, Dr. Dominica Ayini, they all sort of try to indicate that they have lost hope in the judiciary. Now, there were reasons as to why the NDC has said so, and there were reasons as to why the former Deputy Attorney General said so, Dr. Dominica Ayini. And these reasons are ones that have to do with the election petition, the 2020 election petition. Are you saying that those are enough grounds for them to have expressed such sentiments about the judiciary by saying that certain things did not go well in the 2020 election petition, and so the NDC as a party could even say that they have also lost hope in the judiciary?
Well, I don't think those words, like you've just stated, were said in a vacuum. When the then candidate Nana Addo lost the 2012-2013 election petition, what did he say? He said he accepted the verdict, but he disagreed with the court. You understand? One former president, John Dramani Mahama, had his turn. He repeated the same thing. So to disagree with somebody or with a group of people or with the justices of the Supreme Court cannot be equated to scandalizing the court.
That is also different from to lose hope in the same institution you will run to when something or someone is pursuing you.
Yes, when you run to an institution, like I said, you run knowing that this is how the institution performs its task. These are settled practices. At this stage, when you request for this, this is what you expect. When you run there and having had an experience in 2012-2013, you are going in to the 2021 knowing that this has been the practice. When you go there and everything you bring is thrown back at you, don't you have cause to be concerned? Wouldn't you be justified in saying you've lost hope? To lose hope in something due to an event is only to express your dissatisfaction and to hope for a change, because it is the only institution we have as such. In fact, the fact that NDC says it has lost hope in the judiciary does not mean they have an alternative to the judiciary. They don't. But it will also be even more dangerous to say, because it is the only resort we have, let's not even say that we've lost hope, and let's allow things to go the way they are going.
If the NDC feels that...
The NDC is a stakeholder.
Very well.
It's a stakeholder in our national affairs.
Okay.
And the judiciary is a critical arm of our governance structure. And so, to expect the NDC to sit aloof and watch things go anyhow would even make the party a more irresponsible party, because as an institution, the NDC is representing millions and millions of the Ghanaian populace. And these people expect that institution called NDC to, as it were, be a channel through which their grievances can be communicated out. And if the party is also silent because they do not want to be seen to be attacking an institution, then the party itself is not living up to the task given it by its own people. And so it's a duty it has.
As a lawyer, do you think, or can you say, that we have an independent judiciary?
Anybody, any lawyer will tell you his opinion as an individual. And I go back to what Dominic Ayini said. Dominic Ayini said his assessment and his conclusion was based on the 2020 election petition.
Okay. So based on the 2020 elections, what will be your conclusion and assessment of court? Do we have an independent, judiciary?
We have a long way to go. That will be my comment. We do have a long way to go.
We have a long way to go. Let me read a few of our messages. Come back for us to wrap up. This one says, John from Bolga Central. Honorable Ayini did nothing wrong because of speaking the truth of the Supreme Court on the petition. Thank you so much for your message. This one says, the court is corrupt, simply corrupt. From Bolga, you didn't add your name. Thank you so much for your message. Please, good evening. I'm Sunny Amanya from Dambaya. NDC should give us a break. They should stop that cheap propaganda. Thank you so much for your message. This one says, I'm Nana Intema. Good evening. Please, may I know if the present Chief Justice make any comment about the 2012 election petition? Thank you so much for your message. Why are you defending Ayini? Why did he apologize? Well, I don't get your message, but I think the import is clear. This one says, Justice, the judiciary are part of the government and being paid by Ghanaians. As a result, the Chief Justice is not above criticism. Kweku in La Paz. It is interesting to hear what Soprano is saying. The judiciary is a third arm of government. All holders of such positions must act with integrity. Right, you have just referred to a statement made by one of the panel in the morning, but that's all right. This one says, I'm Combat from Nakpandu. Integrity is a value earned not by might. I agree with Prof. Kukwaza when he says laws in Ghana are mere suggestions. What has CJ done to an MP who insulted a judge on live TV? Where was the CJ and respect for the courts? All right, thank you so much for your message. This one says, I'm Nicholas in Bolga. Okay, Nicholas, thank you so much for your message. This one says, it is unheard of that a CJ will instruct his lawyer to tell media houses to pull down anything they have written about the judiciary before a judgment is delivered. It's never heard in our history. CJ is being haunted by his own judgment. Stephen in Kwabenya sent in that one. Stephen, thank you so much. This one says, so are the lawyers and judges always telling us the truth? The ultimate judge is waiting for each and every one of us. Hillary from Nkranza sent in that one. Hillary, thank you so much for your message. He must be blamed because the whole issue was 3 against 1. Meanwhile, the court should have been ready to serve Ghana justice and nothing more, nothing less. I can't get it. Black's Law Dictionary and Ghana Constitution. Which one should be governing Ghana? Where constitution is abandoned. Thank you so much for your message. Justice, majority of Ghanaians have lost hope in judicial system of Ghana by that unanimous FC because it can't be possible for 9 justices to see nothing good about the petition of 2020 election, says Samuel Ebo Kweno. Winneba sent in that one, says Samuel. Thank you so much. Good evening. This is Hassan from Tamale. Ghanaians are in danger this time. You can speak the truth when you talk. They will pick you. They will pick you up. Common NAPCO beneficiaries are crying 3 months. You have not paid them, and they are on TV stations telling lies. Thank you so much for your message. Kwesi Sadiq from Nzema. I thought the issue around the election is over. So why must the Chief Justice hurt the feelings of NDC as a party and Ghanaians at large by lightening the issue about the election petition again? Absolute power corrupt indeed. Thank you so much for your message. This one says, good evening, well spoken Fatal. You have said it all as it is in Dr. Ayini's statement. It was fair. It was a fair comment. Tinkra Alexander sent in that one. Alexander, thank you so much. Chief Justice is showing any independence of the Supreme Court. John from Boga. I don't get your message, John. This one says, good evening, my brother Justice. Justice, there's nothing worse, scandalous, and demonizing our courts and judges than things Kenya Japan has been saying. Sorry. One thing that must be made sufficiently clear is that the Chief Justice is not the Supreme Court. He would not retire and go home with the Supreme Court. There have been Chief Justices before him, and there shall be Chief Justices after him. Dr. Ayini, who is equally a well-qualified person to be a Chief Justice, did absolutely nothing wrong. Jejom in Taifa sent in that one. Jejom, thank you so much. Chief Justice is not showing any. Okay, I think I've read that one already. I have a lot of messages here. Unfortunately, I cannot read all your messages. Let me come back to lawyer for us to wrap up. This one says, NDC members, we are ready to make our minds, and we swear that no Supreme Court again, inshallah. 2024. Oh, sorry, I cannot read that. Unfortunately, you can't say that. This one says, that is Ghana for us. Yes, indeed, that's Ghana for all of us. Justice, Chief Justice Eniyebua acting as a, well, you cannot describe the Chief Justice as such. I won't read that message at all. But lawyer, we would have to wrap up because our time is up. Our time is up. Now, this issue of the Chief Justice, you know, Dr. Ayini and then the National Democratic Congress. Now the NDC is asking that the Chief Justice withdraws the issue and all of that. Your take on that?
And I fully subscribe to that position. And it is my belief that this matter will not go to its fullest extent. That sooner than expected it will lead to rest. Because we do not want to be seen to be engaging in discourses that would further entrench some of the divisions we have as a nation, some of the feelings we have. And so we have the strong belief that having provided his responses there may even be no need for us to probe the matter further. Dr. Dominic Ayine haven't provided his responses to the General Legal Council. There may be no need.
But whilst we are wrapping up on the show finally, is the NDC not seeking public sympathy by organizing this press conference? You know, when there are laid down procedures, the NDC could have followed legally if the NDC feels that there were certain things that did not go well in the Supreme Court petition.
They could have done what? They could have done what?
You mean that there are no,
no, because
available for the National Democratic
It was only going to be an exercise, like I've said before, in futility, because we would have gone back to the same institution.
Okay.
Maybe with enhanced numbers. And that would have amounted to basically nothing. So, this matter was basically dying until this whole petition issue came up.
Yeah.
You understand? And so it tells you that NDC as a party has moved on. You understand? To reorganize themselves and then, but for this petition, maybe we will not have had NDC organize a press conference on a matter like this again.
Okay. All right, your final words. Let's go.
Final words. I am on the firm conviction that Dr. Dominic Ayine knows what he's about. He's a responsible person, and it is common knowledge that after judgment, people are supposed to criticize the decisions, and lawyers are even supposed to be at the forefront of this because they understand the work of the judges better than the public. And so what we think is that if the public are allowed to criticize, lawyers should be allowed to criticize. And maybe we need to make our laws and other processes a bit clearer, what amounts to criticism and what amounts to an insult. It looks like we are not clear on that. When I criticize you, you may take it to be an insult.
Okay.
So there are still some gray areas that have to be ironed out, and it is my thinking that as a society we should pay some attention to some of these areas, and so we don't revisit some of these situations in the future.
Thank you so much, Lawyer, for coming. I'm so grateful for your time. This was time alas on the program for this evening. The program has been Hot News. My name is Justice Appiah, and I've been doing this with Lawyer Al-Hassan Fatah, popularly known as Jofa, private legal practitioner who is based in Ashaiman. Thank you so much for coming.
Thank you too.
You have to take, you have to go through a painstaking journey to be able to get to this place. If you don't love the platform, you wouldn't have been here. I'm so grateful. I'm so grateful. He's my friend and a brother as well. He's my coach too. I mean, he knows what I'm talking about.
So much.
Sometimes when I'm having difficulties, he's the person I pick up the phone and call. I don't understand this legal word. Can you please help me with it? I don't understand this assignment. Can you please take me through? And he does that, with ease. I'm so grateful. I'm so grateful, my brother, for coming.
Always welcome.
Make a time with us same time tomorrow. My name once again is Justice Appiah. The show has been Hot News. Goodbye.